All right. Well, good morning, everyone, and welcome to Sunshine in the Classroom. This is going to be a discussion of open government in public schools in Georgia. I want to give a brief roadmap for today because I think the layout is going to be somewhat unique. We're going to start with sort of a mini training session by Bailey Hotard. Bailey is a Juris Doctor candidate at Mercer, and she is interested in First Amendment and open government issues. So she's going to be giving us a little walkthrough today of how to request certain records in public schools, and then also some tips on attending public school meetings. After the training is finished, then we're going to have a panel discussion. This panel discussion is going to include reporter Martha Dalton. Martha Dalton is an education reporter for the Atlanta Journal-Constitution, covering Fulton County and Atlanta public schools. She's covered education in Atlanta for more than 13 years, and in that time has had many experiences requesting records, some more frustrating than others. Martha is an Atlanta native, which shocked all of us, but apparently they do exist. She has also lived in South Carolina. In her former life, pertinent to today's conversation, she was an elementary school teacher. Then we have Nan Trowell Brown. Nan is an advocacy coordinator of the Georgia Library Media Association. She has been a school librarian media specialist in secondary schools in the Atlanta area for almost 20 years, and we thank her for her service. That's incredible. Brown was named her school district's 2021 Library Media Specialist of the Year and received the 2022 Georgia Library Media Association Intellectual Freedom Award. Intellectual freedom is definitely going to be a topic that we're going to cover today. She grew up in Coffee County, Georgia, where both of her parents were educators. As we go through this next phase, which will consist of the training for about 15 or so minutes, please feel free to send any questions that you may have to the chat. We will watch that chat. For your questions, we'll take those at the end of the panel discussion. And then also, please be sure to keep an eye on the chat because resources will be posted throughout the discussion as we go. After this training and discussion is completed, we will post these slides online at gfaf.org. They'll be posted in the archives. And we're also going to have another resource available for you today, which we're proud to present. And I'm going to let Bailey introduce this resource as she begins her presentation. Bailey?
Hello, everyone, and thank you, Joy, so much for that introduction. As Joy mentioned, my name is Bailey Hotard. I am a JD candidate at Mercer Law, and I'm here to speak with you today about open records and open meetings within education. So without further ado, let's get started. So as Joy mentioned, we have another resource that will be very helpful for this discussion. Over the past few months, we have curated a frequently asked questions document that is available online at gfaf.org. And all the information within this presentation can be found within that frequently asked questions document. And it's actually a bit more extensive than the information presented here today. So again, check out this document online at gfaf.org. Today's presentation is about unique issues within education open meetings and open records law. We are not covering specific logistics of how to request records, deadlines, fees, or anything that is not education specific. But a great resource on these issues is the Red Book available on GFAF's website. So the Red Book is a very comprehensive guide to, as it says, open government in Georgia, which means open records and open meetings issues. Very, very helpful, very useful, and a free resource. Okay, so we begin today's presentation by discussing the kinds of records that are available within education. There are three categories of records. The first is student information, the second is personnel information, and the final category is administrative records. Specific to student information, the Family Educational Rights and Privacy Act, which is more commonly known as FERPA, requires that all personally identifiable information of students and their families be protected. So if you are able to get records the personally identifiable information will be redacted from those records. And as you can see in the first red column, those are things like the student's name and social security numbers, things of that nature. Documents that are generally available include school directory information, student information created after the student leaves the institution, student employment records, aggregate test scores, and law enforcement records. Now, there are some categories of records that are only available with either the consent of the student's parent or the consent of the student if they're over 18 years of age. And those records include medical or psychological records, academic performance records, admissions records, letters of recommendation, and student disciplinary records. Next slide, please. Now, student personnel record or school personnel records means the records of teachers or school staff outside of the administrative team. And similar to how students' personally identifiable information is protected, personnel's personally identifiable information is also protected under open records law. And as you can see, those items, again, in the red column, which are things such as social security numbers, birthdays, things of that nature, will be redacted from any available documents. But there's a long list of documents that are generally available for personnel, and those include applications for employment, background investigations, certificates of training, commendations, criminal history background checks, driver's license, salary and other compensation, some evaluations, reprimands, and training records. And as with students, some records are conditionally available, which include some military forms, some forms of evaluation, and some background investigations. The final category of records are school administration records. And typically the records that are not available have to do with school safety. And these include school safety plans and documents pertaining to personnel who are approved to carry weapons within a school zone. Records that are available include school board records, school budgets, policies, which include curriculum and banned books. And in addition to that, all Board of Regents records, university president or school superintendent search records, and university-related foundation records are typically available. And as with the other two categories, some records are only conditionally available, and these pertain to some hiring decisions, records of test questions, scoring keys, and also records pertaining to any specific school vendors. And a good way to summarize these records is to think about the records that are generally available show your tax dollars in action, whereas the records that are typically protected protect a minor's identity or personnel identity. So keeping with transparency, that the main records that the open records laws protect are those in which your tax dollars are hard at work. Great, and so one school-specific exception to the typical, so typically a school will have a 3-day deadline to 3 business day deadline to respond to your open records request. However, there is a law called Kirby's Law, and this law states that any sort of sports program that is a unit of the University of Georgia will have up to 90 business days to respond to your open records request. And the purpose of this law was intended to protect student athletes' records. However, the law has been written in such a way that it is interpreted to give this deadline to all other athletic records. So while that was not the law's intended purpose, it has now been expanded to include all athletic records. Okay, great. And so now we are turning to school board meetings. And just to give you a quick foundation, so a school board meeting is technically a gathering of a quorum of the members of the school board or any of its committees at which official business, policy, or public matter is formulated, presented, discussed, or voted upon. And these meetings must be publicized regularly. Typically, all the dates for school board meetings are decided once per year, and then they must be publicized for 2 weeks, and they can only be changed once within 12 months. All right, next slide, please. Great, okay, so this slide serves to show sort of the importance of open meetings. And so this quote here is actually a grievance from the Declaration of Independence. And it says, he has called together legislative bodies at places unusual, uncomfortable, and distant from the depository of their public records for the sole purpose of fatiguing them into compliance with his measures. And the he that this quote is referring to is King George. And so this just goes to show that open meetings are a foundational ideal of American democracy. And the purpose of these laws is to promote transparency within our governmental institutions. And for any of you Hamilton fans out there, you'll recognize this man to the right of the slide is King George. And again, you know, it just shows to emphasize that these laws are such a foundational part of American democracy. And as I've mentioned previously, we're only discussing school-specific issues today, but the Red Book that's available online at gfaf.org is such a wonderful and helpful resource when it comes to any other open meetings that across agencies, because there's so many different agencies and so many different meetings. We don't have the time to go through all those today, but I highly encourage you to reach out or to find the Red Book on GFAF's website. Great. Okay, so school board meetings are open to the public, and the public actually has a time in which they can comment or speak to the school board directly, and that's called a public comment period, which I will get into a little bit later in the presentation. But the school board may opt to close a meeting and go into what's called an executive session, which just means that that portion of the meeting is closed to the public for certain reasons. And the two listed here are student disciplinary hearings and some personnel or employment matters related to the executive head of the district. And the school board can also opt to go into executive session for legal matters as well. So those include investigative purposes, mediations, settlement or negotiation discussions, and privileged discussions relating to a lawsuit. So these are all valid reasons for the school board to close a meeting from the public. And since the pandemic, virtual meetings have really grown to be a helpful resource for a lot of agencies, and in addition to the school board. And virtual meetings, there are a lot of pros to those. For example, for citizens who are far away from where the meeting is typically held, you don't have to travel, which is great. And also, it's allowed recordings of meetings to become more pervasive. However, there are some real cons to virtual meetings. Some agencies have really latched on to virtual meetings and have chosen not to have in-person meetings, which, as many of us know from attending virtual meetings, virtual meetings are not as conducive to discussion as in-person meetings are. And so with this in mind, there have been some legal issues regarding virtual meetings. And as you can see here, back in 2020, a school board would not allow virtual attendees into a public comment period because, well, their reasoning was that they couldn't verify that these attendees owned property in the county or that they were district staff members, which they could do at in-person meetings. And so this is an issue because the open meetings law has been interpreted to apply in this exact same way to virtual meetings as to in-person meetings. And so there have been some issues and some violations via virtual meetings that we will be discussing later on in the panel today. This is just to bring your attention to one issue that we have seen. Great, and as I mentioned earlier, a public comment period during a school board meeting is a time where the public may address the school board. And the school board is mandated to have a public comment meeting. However, they are allowed to set their own policies with regard to the length of a public comment period and also the amount of speakers during the public comment period. They may also require you to give notice before you address the board, but they cannot require more than a 24-hour notice. And so again, the public comment period is very important because in the spirit of transparency, it's important to know who is speaking to the school board and who is influencing their decisions. Great, and this is just a quick slide on some helpful tips on what you can do if you notice or you suspect that a violation is occurring at a school board meeting. So first and foremost, you should note your objection during public comment if you can. You should certainly document what's occurring. So take notes, record via video, and just be sure that you have the facts written down if you think that it might be pertinent to any legal action later on. Importantly, you should never be disruptive if you note that a violation is occurring. And disruptive behavior can look like raising your voice, threatening a public official, or just behaving hostilely in any sort of fashion. And if your conduct is deemed as disruptive, then you may be removed from the meeting. And if you're removed from the meeting, then you can't note your objection or document the occurrence. Now, there's some legal action you can take if a public meeting violation occurs. So first and foremost, if the school board takes formal action during the meeting, you can file a lawsuit to have that action invalidated, but you only have 90 days, a 90-day time limit within which you can file that lawsuit. If no formal action was taken during this time, you can still file a lawsuit for injunctive relief, which just means that you're asking the court to tell the school board that it cannot behave counter to the Open Meetings Act. And finally, you can sue the board for civil and criminal penalties. And as you can see here, you can recover up to $1,000 for one violation and up to $2,500 for additional violations, plus attorney's fees and costs if you are successful. And this final point is important because it just serves to show that the school board has a very big incentive to comply with open meetings laws, because if they unlawfully close meetings, they may be recalled from office. And so this is a huge reason that they should comply, outside of just general government transparency, that they should comply with open meetings laws. And so again, these are just some helpful tips. And as we mentioned, if you can't jot all these down right now, this presentation will be available. And the FAQ sheet that I mentioned at the beginning of the presentation is available online at GFAF's website, and we'll have all these tips noted as well. Okay, great. I will now turn the presentation back over to Joy for a discussion on data collection and retention within schools.
All right, thank you, Bailey. Just very briefly, I'm going to touch on data collection and retention. This topic sort of goes hand in hand with open records, but it's something that comes up a lot, especially when I speak to parents who may be concerned about how the school is retaining data on their minor children and what they're doing with it. So if you'll move to the next slide, please. The Student Data Privacy, Accessibility, and Transparency Act of 2015 tries to put some guardrails in place around data collection in public schools. It requires an inventory of the data points that are being collected, including the purpose for the collection. It gives parents the right to review their child's education record and requires schools to provide electronic copies to parents upon request. It requires the development of a data security plan for the state data system, which is very important. It requires technology providers working with schools to also have data security plans, and it prohibits those vendors from selling personal information that they may come in contact with, that they may be storing information about students that they could use for targeted advertising. And it also provides for the Department of Education to designate a chief privacy officer. So very briefly, I'm not going to go into a lot of this. Like as Bailey said, the slides will be available after the fact. But here are some links to some different data glossaries. These are essentially what a lot of data specialists would call layouts that show the types of information that are being collected. In those three orange boxes there. And again, the law requires them to create and publish these indexes or dictionaries of data points that they're collecting. Then before there are any changes to the types of data that they are collecting or how they're being collected, it has to go through a public review process, sort of speaking to the transparency point here. The Department of Education has to notify the governor and the General Assembly of any proposed data element changes, and then it goes through a review and comment period for 60 days, along with some other steps. For more resources on data collection and privacy, if you're interested in learning more about that, we've compiled some important links for you that may be helpful. And then briefly here, I want to touch on this before we segue into our panel discussion, because this new law will sort of begin the basis for our panel discussion. And this is the law of parental complaints regarding harmful materials. So I want to just address this briefly. This 2022 law requires the local board of education to adopt a complaint resolution policy for a local school system to address written complaints that are submitted by parents or guardians, alleging that material that is harmful to minors has been provided or is currently available. If you Google that statute, you're going to find a list of the types of materials that would be considered harmful. Then what happens is that after the parent writes their written complaint, the school principal or their designee will review the complaint, investigate it within 7 business days, and then meet with the parent to let them know whether or not they're going to restrict student access within 10 business days. At which point, if they decide not to restrict access, the parent can then appeal to the local board of education. Once that appeal happens, the title of material submitted for appeal shall be published on the website of the local board of education within 15 business days and will remain on the website for at least 1 year. One of the issues that we've spoken about that I think we'll talk about later is that, there's no transparency requirement except in the event of an appeal. So in other words, if a parent goes to a school and says, okay, I want this book pulled off the shelves, and the principal says, yes, I quite agree with you, that's a good idea, and there's no need for an appeal to the local board of education, then as this law reads today, there's no transparency in that process in terms that 15 business day publishing of the title does not happen. A parent or permanent guardian may request access to appealed materials that are physical and accessible to their student in the school's media center, and a parent or permanent guardian must abide by the school's policy and procedures when requesting and reviewing such material. Now I'd like to go into our panel discussion. If Martha and Nan can join us. Nan, I want to begin by turning this to you, and let's talk a little bit. I know you have a great insight into the harmful materials law, how that works, sort of the intellectual freedom issues. If you could speak to that, please. You're on mute.
Okay, so SB 226, which is the law that passed that changed the reconsideration process, was first introduced as a jail librarians bill in 2021 and went through several substitutions to move the process from a local control situation that generally a committee reviewed the materials to principal or designee. And before it went to a district committee and then to the board after the district committee. But that was changed with this state mandated law. There also was a new requirement that a parent or guardian was the only one who could appeal. Parent guardian of a child at the school which had that title in their collection. And that with some pro-censorship groups, that concern caused a little bit of concern. So we have had situations in Georgia where the group promoting the censorship activity has actually publicly posted recruiting parents at certain schools to file a challenge. This censorship movement is a coordinated national effort, and they are setting up, bases in all different kinds of places across the country. These people have a list of books that they find concerning. Most of those titles that are being challenged, unfortunately, represent either authors or characters from our more marginalized communities, our Black, Indigenous, people of color, and our LGBTQ communities. Very disproportionately, these are the books being challenged. So these people are recruiting people to say, yes, I'll put my name on this. They say, we already have the paperwork set up. All you have to do is sign it and take it to the board. And of course, that's very concerning to us. But they also, I mean, they have it down to the page numbers. Also, what's very concerning about the implementation of this law right now is that another workaround that some groups have somewhat successfully made is they don't take it through the process. They take it directly to the school board. They take it directly to administration to have the books removed from schools, from all schools, not a parent at the specific school, based on obscene materials definition. And as you noted, there is a very specific definition. It's called the Miller test. It's a 3-pronged test. And it's our understanding that only an attorney and a judge can make that determination. But most of these books being pulled would not meet the definition of the Miller test because they're not predominantly written to appeal to the prurient interest of minors. Also of concern related to 226 as that last spring, Senate Bill 154 was introduced, which is verbatim the original SB 226, Jail the Librarians bill. So this has led to obviously concern again within our community between the books being pulled without going through the process from districts and the threat of we will put you in jail for a year if you give this book. When the definition was being applied and almost nothing got pulled, that of course was not nearly as concerning. But now that materials that almost certainly would not meet the Miller test being pulled, it's kind of like the divisive concepts. It's an iteration of divisive concepts law interpretation by local entities.
And I want to pivot here now and go to you, Martha, because I think that Nan has done a great job here of kind of setting up this issue. But obviously, if you're a parent or you're a concerned citizen watching this video and you want to know more about, okay, wow, that's staggering. How do I request records? What are the transparency efforts that I can go, that I can undertake to learn more about what the school is doing? A lot of times parents want to request records about books titles or the school's policies just to get a copy of the policy or the board minutes. You, as an education reporter, have filed many open records requests. I'm wondering if you can sort of speak to some of the responses that you've gotten, any tips that you have on how a parent or just an interested citizen will go about requesting materials relating to these issues.
Yes, and let me first say that my colleague Cassidy Alexander, who I believe is on the who is joining us today, has done excellent work around this topic in Cobb County and continues to. So I just want to point that out. One thing you can do is subscribe to the AJC to read her work, and you can get some good background there. But correct, I think parents who want to file requests, certainly you can do that. And I had an editor once who had covered the legislature for many years, so that she saw Georgia's open records law literally being crafted. And she would always say to us reporters, this law was made to be simple. It was made to be very simple. You're supposed to be able to just ask for the records and they hand them over. And she was in the room when the law was being put together. I think that probably was the intent. In practice, that's not necessarily the case. I think part of her guidance was to get us away from some of the legal jargon about, telling districts, you have 3 days to respond to my request. You don't need to put any of that in your request. I think that's true. You are supposed to be able to ask exactly for what you want and receive it. That doesn't always happen. I've certainly run into circumstances where the records that I've requested I will get a response from the district after requesting records saying the records don't exist. And, you know, I'm thinking of one case in particular with a certain Metro Atlanta district where we got that response and we knew that the records did exist because they had been leaked to us by parents and students. And so, but we wanted, you know, first of all, we wanted the official records. And secondly, we wanted kind of more context. We wanted sort of fuller records to get sort of some more history on how long the issue had been going on. And what I realized the other day talking to you, Joy, was that we probably should have come to Georgia First Amendment Foundation for advice. But for us as a nonprofit newsroom at the time, it came down to a matter of resources because we kept going back and forth. And we got to a point where we thought, well, we can get lawyers involved, but then, you know, that's a huge investment in time and resources. And meanwhile, there's other news going on. So for us, you know, eventually it came down to how do we want to spend our resources? For parents, hopefully that won't be the case for you. I would say if you run into, you know, a problem like that, first of all, consult Georgia First Amendment Foundation, like we did not. Consult them, but also continue to ask, you know, and maybe perhaps remind them that the intent of Georgia's law is to, you know, ask for records and receive those records. If you have to get on the phone with somebody, I would say get on the phone with them because it is the intent of the law is supposed to be very simple, that you should be able to ask for what you're trying to see and you should receive those records.
And I want to ask this just briefly as a follow-up question, Martha. Have you found, you know, what Nan is speaking of with this national effort, like it seems like there are some new trends popping up in schools with anti-transparency measures, largely because a lot of the things that they're doing are unpopular with a majority of citizenship. But you know, have you gotten the sense that responses to open records request in Georgia, is that something that has gotten worse in recent years? Is it getting better, or is it sort of always been this way? What's your sense of that?
I feel like it's probably about the same, that it's always been, you know, a little tough in terms of the what Nan was referencing, parental complaints and divisive concepts and things like that. It's interesting, I think, in Atlanta because those concepts are more those statutes are more popular in some districts than others. I cover Atlanta and Fulton County. They're not huge. You know, Atlanta passed a resolution opposing the divisive concepts law as it was being crafted. They're not big on that. In Cobb, I think, you know, the board is dominated by Republicans, and I think it's more popular there. You know, it's sort of interesting to see the difference district to district. In Forsyth County, obviously, last year, they went through a similar kind of issue with pulling books from shelves. And if you watch some of those school board meetings, it's a little bit heartbreaking to see some of the students show up and say, you know, please don't do this. You know, this, some students who are maybe in marginalized groups showing up saying, you know, I connected with this book. It really helped me kind of feel like I fit in middle school, you know, that kind of thing. So I think it just sort of depends in terms of those laws and the new laws that are sort of bubbling up. It kind of depends on what part of the state you're in and what district you're in as to, you know, sort of what the enforcement level is. I know that in Atlanta, there's just not a huge appetite for, you know, being really strict about divisive concepts. Whereas, you know, I think in Cobb, it's a different story.
And I want to say, you know, we're talking a little bit here about politics, and I think it's a good moment to inject the fact something that I find really fascinating and beautiful, actually, that public records and transparency is a nonpartisan, or I guess bipartisan, rule, and what I think is really interesting is that I don't think a lot of people understand that this notion of transparent government applies evenly. If you've got a conservative school board, maybe removing religious literature. If you have a liberal school board, maybe removing other kinds of like whatever it is, there are plenty. Red or blue, we can all agree that parents need to know what's going on in the schools, and the community needs to know what's going on in the schools. And so that's one of the things that I think is really nice about public records and public meetings, is that it should be the thing which unites us, that regardless of whatever your views are about any of these topics, the fact remains that it's a nonpartisan principle of an accountable, just good government. Nan, I want to go back to you for a moment, because I want to talk a little bit about specifically the librarian's role in these intellectual freedom challenges, and sort of, if you can speak to kind of what, if any, pressure this places on librarians, and maybe efforts that librarians are able to undertake to sort of be a liaison between the public and the school administration for intellectual freedom issues in schools.
Sure. Librarians are very aware of what is happening across the country, particularly Florida, Texas, Tennessee. Librarians have been threatened. They've been harassed. I mean, people have been placed in very, very uncomfortable situations. And our code of ethics say that we will fight censorship, but then people sometimes are in the quandary of, do I stay and do what I can rather than let them replace me, than leave and let them replace with someone that won't push back at all and won't work to fight what needs to be done for what needs to be done. And we also are advocates for parents' rights. We fully feel that parents have the rights to manage their own children's reading options. Nothing in a library has to be finished. Nothing in a library has to be checked out. But their rights end at their own children. And that's what we're fighting right now, is people who want to manage the reading rights of all the children in a building. We, as an organization, have advocated with decision makers, with school board members, with our state legislators, obviously, in these bills and everything. And we know that the vast majority of Americans agree. Every library did a survey in September 22, and 91% of the voters they surveyed agreed, or somewhat strongly or somewhat agreed with the statement: if you don't like a book at a library, don't check it out. Other people should not be able to control what my family or I read. So we know it's a huge majority that say stay in your lane, right? Only 8% of the voters I surveyed thought there are many books that are inappropriate and should be banned. Those numbers kind of line up, right? But outsized voices from these organized groups make it feel like that's not where we are. When the people showing up and speaking at school board meetings, there certainly are, and we so appreciate our allies. We so appreciate these groups outside education. Of course, Council of Teachers of English, GLA, lots of other people are advocating for intellectual freedom, but legislators tell us that's your job to do that. Of course you're going to do that. I'm hearing from a lot more parents concerned than I'm hearing from parents concerned about books being removed. So what we need is people to show up for that. And just for statistics of what is happening, ALA's last survey of banned books found that 90% of the overall number of books challenged were parts of attempts to censor multiple titles. 40% were challenging 100 or more books, and 38% were cases between 10 and 99 books. This is a whole different scenario than we have dealt with in the past, where a parent sees a book from their child's school, expresses concern, we have a conversation to talk with them about You know, in a middle school, we may have 10-year-olds when school starts. We have 15-year-olds in the building, and meeting the needs of a 15-year-old as far as what they need to grow social emotionally, information wise, is very different than a 10-year-old. And we can't restrict what any 15-year-old can read based on what a 10-year-old. We can identify those books with mature content so they know before they open them that it's a book with mature content. But we can't say every child in the school can only have what's appropriate for the youngest, first in the family child at 10. And so it's a real struggle. We really need people to speak up. We need them to hear the 10-to-1 number in editor's letters to the editor. In being interviewed a lot, one positive thing is a lot of our news sources have picked up on this story. When 226 first started, it wasn't covered very much, but more and more we're getting it covered by the news sources, and we need people to speak to their school board members and their legislators. Just in the past, very, very recently, there was press release saying that 3 legislators in Georgia had signed on in concern and asking that the Georgia Library Association and Archives disaffiliate with the American Library Association for concerns regarding, because what we're being called by these groups are groomers and pedophiles, and we're indoctrinating children. There's a lot of really bad press about librarians, but when you look at the surveys, and I think these are posted here, you know, the vast majority of people feel like libraries need to provide a wide range of resources, lots of different perspectives, and they trust teachers and librarians to do that. We just need those people to speak up and let people know this is what we want.
And on that point about people speaking up, it's interesting because I get a lot of calls about participation in public meetings. And I think that there's sort of this fear a lot of times among folks who maybe aren't used to going to public meetings or aren't used to speaking at public meetings, that they're going to do it wrong. You know, that they're going to stand up, or they're like, you know, they don't want to stand up and say, I think you've broken the law, because that, as you said earlier, well, that feels like a call an attorney should make. But as I advise people all the time, there is nothing problematic about anyone saying, you know what, I want to flag this issue. I think it may be a Sunshine Act violation. I think there may be an Open Meetings Act violation here. I don't feel, even if it's not, I don't feel like this was the most transparent way that the board could have handled this process. There is nothing wrong with that. And I encourage people to do that. Whether or not you have a child, if you're interested in education issues, if you're interested in, you know, your community, I think it's a great idea for people to, you know, look up their local school board meetings and attend. Just attend regularly, get a sense of the way business is being transacted, and then speak at public comment if there's something that you want to say. It is open for the public. It is for the public. And on that note, I would like to go to you, Martha, for a moment, because we know that unlike most agencies or all other agencies in Georgia, local boards of education are required to have a public comment period. So that's a relatively new thing. How have you seen that played out in practice in your coverage of school board meetings? And do you have any concerns about how some boards are maybe approaching that requirement?
Well, how it plays out usually for the big metro districts is that they usually allocate a certain amount of time. So say an hour or a half an hour, something like that. And because there are typically a lot of people who want to comment, they will limit each person's comment to 2 or 3 minutes. I think some districts have moved from 3 down to 2 now because they've had so many people showing up. So typically, if you want to show up and comment on something, you'll have, I would prepare for probably 2 minutes, but that's something you could find out on your district's website, what the length of time is. It can be a little bit awkward because essentially, speakers are just going one after another. So when the first person gets 2 minutes, then it goes to the next person who gets 2 minutes. The board will not interact with you during that time. So it can seem kind of strange. You'll talk passionately for 2 minutes about whatever it is that's important to you. Then your time is up and they go on to someone else and they'll just say thank you usually, and they won't give a response. So it can seem a little bit strange. If you do want a response, you can request it while you're speaking and say, I would like a written response. I think they have 30 days. The board has 30 days to get back to you in writing, but they're not going to respond at the time. So it can seem a little strange, but just be prepared for that. If you want to speak, that you'll be able to say your piece, but you won't get an on the spot in the moment response. It's not an interactive process. The other thing I was going to mention is that public comment doesn't have to be limited to, or by law, it's not limited to a school board's monthly meeting. So it's any meeting where they have a quorum of board members. So it could be a committee meeting, or it could be a work session meeting. Any of those meetings where there's a quorum of board members, they have to hold public comment. So you don't need to feel like, oh, I couldn't go to the monthly meeting. I won't get to comment or say my piece about whatever issue. The other part of your question, I believe, was, do I have concerns about how it's conducted? A little bit, because it does, the way districts handle it right now without interacting with speakers, I understand why they do it. You could get into, a back and forth that's really contentious and not productive. At the same time, it does seem like there's a little bit of a disconnect between public discourse and the board. So in a weird way, it kind of it creates this separation that seems a little unnatural. I think there probably could be a way where you could set up interaction where it doesn't, if things start to escalate or it starts to get contentious, you could shut it down, because it does seem a little, it seems a little strange. As someone who's attended a lot of school board meetings, it's good to have time for people to be able to speak publicly, but at the same time, it's just it can be a very odd and just sort of awkward exchange. It's especially if there's a topic going on within the district that a lot of people are upset about on either side, whatever issue it is. Let's say one thing that happens a lot in Atlanta's different districts is that, a superintendent will get let go. So there are often people on both sides of that issue wanting to talk and being very fired up about it. And then once they've said their piece, there's just no interaction with the board and they move on. And it seems like there's probably a better way to engage in public discourse. I understand why, why they wouldn't want to get into a screaming match, but at the same time, it just seems a little bit, it's a little awkward and maybe not completely.
I can imagine it would be very disconcerting, to someone who is attending a meeting for the first time. I tell people a lot that it's also fine if you don't feel equipped to fully speak on an issue. It's totally fine to just stand up and say, I disagree with X. I agree with X. For the board members who are keeping tally marks, of public opinion, that can be enough. That's a full sentence. That's a full position. You don't have to necessarily cite to statistics or go through a whole, if you're not fully ready, to give an oration, you can just say, you know what, I don't agree with the board's decision on this, and sit down. Briefly before we move on, I'd like to talk about virtual meetings. I know Bailey mentioned virtual meetings, and there are pros and cons to virtual meetings. Martha, do you have any opinions on post-pandemic public meetings and school boards and how that's played out?
Yeah, I think, well, on the upside, I think it's good that most districts are doing it now. Some weren't really doing it pre-pandemic, and I think the pandemic kind of caused them to look at that and realize that their meetings weren't accessible to everybody. So most that I can think of now have virtual meetings, and I think that's good in that more people are able to see what's going on. Some districts, including one of the ones that I cover, do not air public comments as part of their virtual meeting, and I think that's probably a mistake. They say the reason that they're doing it is because some people will show up and want to sort of get a viral moment going. And while certainly that could happen, although probably less at a school board meeting than other meetings, I think having a place where the public can come and, express their concerns might be more important than the chance that someone would try to go for a viral moment. I mean, I think there are ways to deal with that probably, and it's important, I think, for the public to be able to speak, and they can show up and speak in person. They still have the public comment period. It's just not part of the virtual meeting. So it's also a little bit strange because the cameras go off for just that part of the meeting.
And I want to go back here now briefly as we close out our discussion. Nan, I'd like for you to speak to the role of the Georgia Library Media Association in protecting intellectual freedom, and also the Library Bill of Rights, and how these organizations are working to advocate, for parents. I know you've already touched on that, but I'd like for you to, to provide any additional insight as to the specific role of the GLMA.
So we, have advocated, like I said, with decision makers locally and with our legislators. At this point, we are trying to find allies. That is our big thing, is locating the allies. We are part of the Georgia Coalition for Education Justice. And we have worked with Georgia Youth Justice Coalition, which is an amazing group of young people. And with groups like, we have a Freedom to Read Georgia essay and video contest. And with that, we collaborate with the Georgia Library Association, Georgia Council of Teachers of English, and Georgia Association of Instructional Technology to try to get our student voices. One thing is, we want our communities and our legislators to hear how the children feel, because who's impacted by this? The children. Right. And we know from being at the legislature that sometimes it's harder for them to ignore the voices of young people. Like it's easy to tell us, I just don't have time. It's harder sometimes for them to say that to students. So we find that's really important. We're trying to elevate those voices and the eloquent stories that they have to share about what being able to read freely means to them. Kind of like Martha alluded to the Forsyth County School Board meetings. It's hard to listen to a child telling the struggles they've been through and how a book or books helped them navigate that. And one other point I wanted to make about when you mentioned the challenge materials being posted, back to the open records thing, the only ones posted are the ones who were retained after appeal. The only way parents are going to find out, I think, what's being removed is open records requests, because there's no public posting of, okay, we removed these, we kept these. So that's really important for parents to know. I would advise people, because of these groups we're collaborating with, Forsyth Coalition for Education, which kind of became the big, Forsyth was the first big censorship situation where they pulled books administratively. A group advocated for you follow your process. Your stated board process is to go through reviews through committees. When the group that submitted the 30 books got 9 pulled, they were like, yay, okay, how about the other 21? And we have 50 more, right? Then the administration said, oh, let's go through the process kind of. And they approved all but one of the books to be reinstated into schools. So advocacy from the local community group was huge in that case. So I invite people, if you, to your point, of people who are uncomfortable about speaking before the board, those Forsyth County School Board meetings are very interesting. You can see there's some incredibly eloquent people speaking on behalf of students, and as part of the access to lots of materials. And the stories, they're great storytellers. They bring the facts, they bring the stories, and then you can see the other side. And I think if people watch some of those, they'll go, I can do better than that, right? So those are great situations. And then the final thing is, because it's a national effort, there's a national effort to censor books. There are also national efforts to oppose it. And I would invite people to go to the Unite Against Book Bans group, which has a toolkit, and they actually have talking points. They have how to draft a letter to the editor, the parameters for a letter to the editor, how to frame your speech to the school board. It's a lot of really hands-on, valuable information. So see if there's a group in your community. If there's not a group in the community, you don't have to sit there and do nothing. You can follow the United Against Book Grant, use that toolkit to see. They'll have the statistics for you. They'll have the things that I think that people, those 91% of people who think that, stay in your lane, that we encourage people to do that, because right now it's just the banners have a megaphone, it feels like, in school boards and communities.
That's such a tremendous resource. I think that's being posted in the chat. We have a quick question here. I just see one question. We have a few minutes left. In our current political climate, how do you think we can instill a sense of hope and possibilities in young people who want to pursue education as a career? And I'll add to that, not just education, but any type of work, right? And First Amendment or transparency law. How can we instill a sense of hope in young people? Nan, if you want to speak to that first, and then Martha.
Okay. I would suggest you go to that Georgia Youth Justice Coalition page. Like, those kids are incredibly eloquent and passionate and believe that things can be changed. And as people who are looking at those kind of careers, if they're involved in that kind of group where people are advocating for equity in education, they're really inspiring, and the other groups. And I think some of those were put in the committee because Martha mentioned, statewide, how Metro Atlanta is different, but there are groups in other parts of the states that have been activated. Columbia County, right outside of Augusta, there's a group there that's been activated to several years ago, before Forsyth actually. Their superintendent removed books from the schools, and then they noticed patterns. And there's a pattern. I know we're only talking schools, but there's definitely, the same people who are going to the public libraries are primed for the school situations, right? So there is overflow. So the Okefenokee Library Advocates, they activated on a public library situation. But that also made people aware, not that there's a problem in their school system, but to just be on alert for that.
And Martha, I'll give you an opportunity to speak to that as well, if you'd like to share.
Sure. I think from a teaching perspective, lawmakers actually listen to teachers, believe it or not. Even if they don't necessarily agree with what they're saying, the teacher voice is really important to them. So I would say, in terms of optimism, your voice will be heard. I know that teachers have a lot on their plate and they may not, they definitely don't have time to say lobby down at the legislature, but I think even just reaching out to lawmakers and things like that and making sure that your voice is heard, they listen to that, they respond to that. So I would say, you know, just make sure you have a seat at the table. They will respond even if they don't like what they're hearing. So
thank you both so much. I think all of that is 100% on point. You know, the only way that these issues get better is if talented, dedicated folks devote their time to improving them. On behalf of the Georgia First Amendment Foundation, we want to thank you for attending our webinar today. As I believe Kathy just said in the chat, today's video slides and resource links will be sent to attendees in a follow-up email. If you have any additional questions, please feel free to reach out to the foundation, to myself. We are always more than happy to talk to folks about how to request public records and how to attend public meetings. Thank you again for your time and attention, and great rest of the afternoon to all of you. And thank you to our presenters as well for the excellent discussion, and to Bailey for her presentation. All right, thank you all. Bye-bye.